the final disposition has put some things on the record, and it is undisputed that your client is a registered sex offender.
He actually was pled guilty to attempted sexual assault.
Good morning, everyone. We're on the record on the case number D23. D, may I have your appearances for the record?
Good morning, Your Honor. Sheila Tajbakhsh, number 15343, here on behalf of the present to my left.
Thank you and good morning. This matter was set to be heard at 10 o'clock. The time is now 10:30 a.m. or 10:31 a.m. We will be proceeding in this matter. I will let the record reflect we do have Mr. Daniel and Ms. Dory from our Nevada judges who are present as well. I believe that names are redacted for purposes of any publication, correct? Thank you, sir. Okay, this is the time set for a calendar call. I do have you guys down for your evidentiary hearing full day, April 19 at 9 a.m. Are you ready to proceed?
Yes, Your Honor, and just a couple housekeeping matters when the court is ready. We were able to file our, thank you.
If you're speaking, say
yeah, thank you. We were able to file our pretrial memorandums. I do appreciate the court giving us a couple extra days on that, given everything that's happened in this case. I did file an ex parte request to strike plaintiff's pretrial memorandum. I'm not sure if the court has been able to see that yet. It mirrors a previous pleading that we actually did strike from the record. In a footnote, it's inflammatory to say the least. My client's photo is pasted in the child custody section. Previously, when plaintiff was being represented by Mr. Schneider, he did let the court know on the record that Ms. Kramer was the one drafting the pleadings and he was signing them. She was helping him. Now with Ms. Sissick on this case, this pretrial memorandum, again, it appears that Ms. Kramer has drafted these pleadings again, called my client a murderer, almost a murderer, and called him a rapist, and has brought up issues that haven't even been discussed in the last 14 months in this case, has made misrepresentations such as plaintiff hasn't provided my client extra time with the child, which she agreed she has. The pleading has not only interfered and thwarted any attempt that we had made, any steps we had made toward resolution in the last few months, but it absolutely has no place in this, in the underlying matter. I would ask that the whole pretrial memorandum be stricken. There is no legal argument in it that is of any significance. Not only that, I would like the court to know that I was so surprised seeing this. We did have a deposition a few weeks ago of the plaintiff. Afterwards, we were able to sit down, four of us, myself, my client, Ms. Sissick, and plaintiff. We got a couple of issues resolved. Minor issues were resolved. The co-parenting has been extremely pleasant between plaintiff and my client. Plaintiff has provided my client more time this last week with the break. My client has had 5 days with the child, but now all of a sudden he's compared to a murderer in the pleading. So I would just request that the court strike this pretrial memorandum. We did submit a proposed order to the court. It's extremely, extremely disappointing that this is where it's gone again. You have already warned the plaintiff in the past to submit pleadings like this. I'm not sure who's submitted these pleadings, but at this point I am requesting sanctions because this is the second time we've had to do this.
Okay. Thank you, Ms. Tajbakhsh. Now, I am familiar with this case, as you guys all know, and I do recall in the other pleadings that were filed by Mr. Schneider was counsel, there was language in the reply. I think you're referring to the reply.
Yes,
that was filed, and I actually have it highlighted because I went through this case. And there was language in the reply where the adjectives such as violent, disgusting, or were used. Ongoing campaign of abuse and terror were used. There was language in there regarding another unrelated case, the Rhode and Dorothy Mendoza matter, which was completely unrelated to this case. And there was language in there that I did find was inflammatory, which is called what said like all abusers and sicko perverts, disgusting perverted actions, pathetic, frankly disgusting attempts, and then it said in capital letters is a rapist with an exclamation mark, and it had disgusting perverted rapist and dominion and control. So it had some highly inflammatory language. Narcissistic, it called Mr. narcissistic abuser, and said he needs to control his ego. And this was written at a time prior to the disposition, the final disposition of the criminal case, I believe. This reply was filed, I believe, prior. I think this was on or about September. I think let me double check. Yeah, August 27th. So August 27 is when we were still in the criminal case. It was still very preliminary. There weren't any findings or any actual decisions that were made. So considering the timing of when that reply was made, which was prior to any disposition in the criminal case, and the highly inflammatory language, I did agree with striking it at that point. The motion was already filed, the opposition was filed, I already was familiar. There was conversations and stipulations on the record that were made. Comparing it now to this one, the current pretrial memorandum, now we're at a different time. Now we do have final disposition. And I want to be very clear. The final disposition has put some things on the record, and it is undisputed that your client is a registered sex offender. It is undisputed that your client did plead guilty to essentially doing what was described in this pretrial memorandum, which is inserting a part of his body into a part of another child.
He actually, it was pled guilty to attempted sexual assault.
Okay.
So it was not the same, it was completely different, it was a plea.
Okay, so, but he is a registered sex offender, so the language for registered sex offender is accurate. So I went through this document page by page, because there are some things here that I will agree that need to be stricken, but I disagree with striking the entire document. The pretrial memorandum had legal arguments. It did have zealous advocacy, and I recognize there's sometimes a line between zealous advocacy and highly inflammatory, prejudicial, scandalous language. I don't believe that the entire pretrial memorandum was highly inflammatory, prejudicial, or scandalous compared to what I referred to on the reply, which I do believe was. Looking at this page by page 1, page 2, page 3, while it does have a picture, it's not necessarily highly inflammatory because it's public record. It's not a picture of him doing anything. I can go in, pull this up. This is public record. The court can very well take judicial notice of the criminal case, which I have done in other matters, and I'm very likely to do in this case. Is it going to throw the whole case out? No. It's just one of the findings that the court can make, but at the end of the day, I must look at the best interest factors of this child, which has several factors, as you both know, pursuant to NRS 125C0035, subsection 4, A through L. So looking at this document, the language that refers to him as a registered sex offender, I don't believe is highly inflammatory. I actually believe that it is an accurate representation. So you're stating here that, again, this is argument. So we're saying that when you gave her, I'm referring to page 4, I think is the first part, page 4, lines 24 to 25, or actually the whole bottom paragraph, when daughter was 17, he gave her alcohol and cocaine, and then he inserted his inside her. Counsel has repeatedly argued to the court that it is uncivil to call a rapist. However, when a man inserts his inside a child, he is deemed by society to be a rapist. So that's the language that is argument, but you're stating it's not factual.
Yes, Your Honor. We're stating it's absolutely not factual, and it's not. Okay. It's not even found in the criminal case that it happened. Okay. So if that language was not found in the criminal case, I will agree with striking that sentence that I just stated. The next paragraph, though, is accurate. For his crimes, was charged with sexual assault, child abuse and neglect, use of CS in presence of a child abuse or neglect. Ultimately, he took a plea to a lesser charge because he no doubt knew he was facing serious prison time for his disgusting crime. He is a registered sex offender. That's all accurate. I don't find that inflammatory. They're calling it a disgusting crime. That's a matter of opinion, but it's not highly inflammatory, and he is a registered sex offender. So that language is appropriate. Moving on to the next page, page 5. That was page 5. Moving on to page 6 at the very top, now is an admitted sex offender. That's accurate. Page 6, line 20. Sterling will find out that his father drugged and raped his big sister. Arguably, raped is a word that was not found by the criminal court, correct? Correct.
So we can strike raped and put that he's a registered sex offender. Anytime it says the word raped, I would just say that it will be replaced by that he is a registered sex offender, period. So, and that goes throughout. Anytime he's called raped or the word raped, it should just be replaced with he is a registered sex offender. Going on to page 7, it states that there is still a TPO. Is there still a TPO?
No, Your Honor. It expired March 12th of 2024.
Okay, so there was a TPO in place. Again, we can strike the words, and there was a TPO in place, though. Is out of control and dangerous. I will strike that language. Page 7, lines 12 to 13. I don't believe that there has been any finding by this court that he was out of control or dangerous. Again, that's argument, it's not necessarily fact. Going on to page 7 at the bottom, anything where it says raped, we can say is a registered sex offender. Language regarding sticking his inside the girl he raised can be replaced with was found to be a registered sex offender against the girl that he raised as a stepdaughter. So that's on line page 7, lines 22 to 28. If that next sentence, if he did not want to be called a rapist, is not saying he's a rapist. It's saying if he didn't want to be called a rapist, he should not have. Again, replace the words raped with he should not have been found to be a registered sex offender. Again, page 8, the language at the top says he's a registered sex offender, so that's all fine. The language that says on page 8 at the bottom, lines 24 again through, it says the part that says he stuck inside her can be stricken. And it does say correctly, he is now a registered sex offender. He is not mental, stable, or healthy, his argument. I'm going to keep that there. Moving on to page 9, registered sex offender is mentioned on line 8, that's fine. Line 17, we can take out raped her and just say he is a registered sex offender. Line 21, the language there is accurate, and again, struck his inside of her can be replaced with he is a registered sex offender. Same goes for page 10, line 14, stuck his inside of her will be replaced with he is a registered sex offender. And line 21, he raped a child, he's a registered sex offender against the child. The rest of the language I would keep as accurate. It says sex offender. I do agree on page 11 to strike the language regarding the Marvin Ray Patterson matter. That is unrelated and prejudicial and definitely impertinent. So that language is on page 11, lines 20 through 24. Beginning with the language, the court cannot forget the case of Marvin Ray Patterson, an accused sex offender who killed his wife and 2 of his 3 children on December 11, 2023. Is no different. He is an enraged, violent sex offender. He wants revenge, period. That can all be stricken. The last sentence is not safe around his argument. You can keep that there. Moving on to page 12, on line 10, the phrase when he stuck his inside his daughter can be replaced with when he was found to be a registered sex offender as to his daughter. Let's see. I think I've searched throughout. That's the only part. The rest of it was legal arguments. If there was anything else where I missed, where it does call him a rapist, or where it does say that he stuck his inside of his daughter, I will allow that to be changed to here as a registered sex offender. The remaining part of the pretrial memorandum, the court does keep intact and is refusing to strike the entirety.
Thank you, Your Honor. Did the court want us, since we did the ex parte request and the objection, does the court want us to file a separate objection to the witnesses that were just identified in the pretrial? Or will the court just take note of what was filed in the ex parte request?
I do take note of that. I do, for family court cases, I like to be liberal in allowing witnesses to testify, but of course we have to be cognizant of the time. You guys only have a full day and I'm not giving you guys more than that. So it will get to a point if there's witnesses that are speaking about, how great they are at it, but they don't have any actual recipient knowledge of seeing the family day to day on a regular basis, not 10 years ago, but today, then I will agree that they're irrelevant and their testimony is not relevant.
Understood, Your Honor.
I would need the plaintiff here to be able to testify to what was their offer of proof regarding these witnesses. However, the plaintiff has failed to appear. Therefore, the plaintiff's failure to appear at this hearing and failure to oppose what you're requesting is going to be deemed by this court as meritorious. And so I will go ahead and allow for the witnesses 4, 5, and 7 who were not disclosed until March 19 to be stricken. And witness number 6, who was only disclosed in the pretrial memorandum, to be stricken. Plaintiff has failed to appear. Plaintiff has failed to set forth any arguments or compelling arguments as to why these witnesses who were disclosed after the close of discovery should be brought forth. And of course, the court makes this finding without prejudice, but we're on the cusp of trial and we need to move forward.
And Your Honor, at this point, I would have to request fees. I mean, this is calendar call. Plaintiff has had notice of this hearing since day 1. This isn't cheap for my client to be here either. So I would the court be inclined to preliminary awards so I could do a memorandum of fees and costs?
For your purposes of appearing at today's hearing, yes.
Perfect.
Just limited to the purpose of appearance, so your time that you're here in front of me, not the preparation and everything else.
Thank you.
Thank you, yes. Due to plaintiff's failure to appear in court today, I will grant a very preliminary award for Ms. Tajbakhsh's services in having to appear in court today. The trial date stands The motion that you filed, Ms. Tajbakhsh, is granted in part and denied in part, as I stated herein. If you'd like to go ahead and make those necessary redactions to their PTM and submit that, you can.
Thank you.
Okay. And trial date stands. I'm sure you guys have submitted your PTMs. I mean, your exchanged your exhibit list and everything.
Yes, Your Honor, and I did want to ask the court what would you like? When would you like the exhibit books delivered here?
3 days prior to trial.
3 days prior. Okay.
Yes. If you can take it upstairs to the 3rd floor, 3 binders, please.
Absolutely.
Okay. And if there is a lot of evidence, I also do welcome uploading it into FC evidence. That way I can look at it electronically.
And is the court okay with front and back to save paper?
Yes.
Okay.
Okay, excellent. Thank you, Ms. Tajbakhsh. We'll see you guys April 19th.
Oh, and Your Honor, I'm sorry, one more issue. I know there's a show cause hearing in the grandparent visitation case tomorrow for lack of preparation of an order. I would just ask that my appearance be waived so my client doesn't have to pay for the order.
Sure. If you just submit the order, it'll all be vacated, so.
Okay,
you don't
well,
have to-
I wasn't sure if Mrs. Sisik was supposed to, she was supposed to do the order, I just didn't know if.
Oh, yeah, your client's appearance is waived.
Beautiful, thank
The
you.
attorney that was supposed to draft the order is the one that has to show cause. The rest of you don't have to.
We just got the notice, so we wanted to be sure.
Yeah, no, I
Thank you, Judge, I
appreciate it.
appreciate it.
Thank you. All right, thank you all. We'll see you April 19th.